Stand, please. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-7116. Chazz Clevinger versus Advocacy Holdings, Inc., doing business as One Click Politics, appellants, Raymond Zemkik et al. Mr. Romano for the appellant, Mr. Chase for the appellate.
Good morning, Mr. Romano. You may proceed when you are ready.
Good morning, and may it please the court. My name is Anand Ramana, counsel for the appellant, Advocacy Holdings. I would like to reserve 3 minutes for rebuttal. This is an appeal, an interlocutory appeal of a denied preliminary injunction motion seeking to enforce a non-compete against its former CEO. The district court analyzed only one of the 4 preliminary injunction factors, whether we established irreparable harm, and concluded that despite concluding that it was, quote, a close call, that we had not. We present one assignment of error, but there are actually 2 questions before this court. The first question is whether we, in fact, or at law, established irreparable harm. And the second is, if so, does this court have the record to make the full determination that we are entitled to a preliminary injunction? The first question is dispositive, so I'd like to start there, whether we established irreparable harm. We established 4 facts in the preliminary injunction proceeding, 3 of which are undisputed. And of those 3, 1 is dispositive. The dispositive fact is the non-compete agreement itself. That agreement contains a contractual stipulation by Mr. Clevinger that irreparable harm would result if he violated the agreement. That agreement is also governed.
Can you please speak to whether you forfeited your argument about that stipulation before the district court?
I don't believe that we did, Your Honor. We submitted the evidence in our original preliminary injunction motion. The court ruled on that motion in the footnote 2. And then on reconsideration, the preliminary injunction, the initial preliminary injunction motion was denied without prejudice. So our view is that all of the issues are live if we bring them back. When we brought them back on reconsideration, we supplemented, and there's extensive briefing on that.
I think as a general rule, you can't make arguments on reconsideration that you could have or should have made in the original motion. And it sounds like from what you're saying, you didn't make any argument about the stipulation in your original motion. You included it in it's in the contract, and you included the contract in the evidence. But was the district court right that you did not make any argument about the stipulation?
I don't know if the district court ruled on that, but Your Honor is right. We did not have any. We did not present any explicit argument on that subject. I think the difference here, though, is that this wasn't just a straight denial of a preliminary injunction motion. The way that the denial was structured was that it was a denial without prejudice. So this isn't something where the court has ruled on it, let's move on. It was the court has ruled on it, but we're really not sure. I'm inviting you to bring it back, which is what we did. And so I agree, though, that, Your Honor, we didn't make any explicit arguments in the initial preliminary injunction motion.
There's no issue about, you had the stipulation, and if you were going to rely on that,
correct,
it was fully available, and in fact, already before the court, in the initial motion for a preliminary injunction.
That's correct, Your Honor. Not only in the initial preliminary injunction, but in the 4 preceding TROs, all of which were granted in full by both the Eastern District of Virginia and the lower court here and the district court here. So the evidence has been in the records really since we filed the complaint in the beginning, but I can't say that we made the explicit argument on preliminary injunction. So Delaware law controls this issue as far as we're concerned. This is a substantive issue. Why? Because Delaware law breathes life into the stipulation, the strength of the stipulation. And what Delaware law says, the Marietta case, the Martin Marietta case is, this is alone sufficient to establish the second prong of the Winter test, the irreparable harm. That's the end of the inquiry. Why? Because when you sign a contractual stipulation like that, Delaware says you are waiving your right to contest the second prong in a preliminary injunction here. Now, that doesn't mean that we don't have to prove substantial likelihood of success. It doesn't mean we don't have to prove balance of the equities or the public interest. We still have to prove that on a preliminary injunction. But Delaware law says you are waiving your right to contest what is really the hardest, in many cases, the hardest prong to prove. So that in and of itself is dispositive. That's an error of law.
Mr. Romano, that case, that was Chancery Court in 2012.
I believe it was the Delaware Supreme Court in 2012.
Supreme Court 2012.
Correct.
And since then, we have 3 instances from the Chancery Court, 2015, 2022, 24, observing that the stipulation of that sort is not binding on the court if there's not some evidence beyond the stipulation to support a finding of irreparable harm.
Right. And the difference here, I agree with that, Your Honor. That's what the Chancery Court said. I don't think the Supreme Court has said anything. But the difference here is...
Well, in Martin Marietta itself, when the court says the contractual stipulations as to irreparable harm alone suffice, it also noted that there were facts supporting
Correct.
that finding.
The difference, I think, the distinction, and I
So
agree.
we get conflicting statements, but there's never relief in any of these cases unless there were also facts in the record to support.
I agree with that, Your Honor. I think in the very nuanced distinction is it alone sufficient? Yes. Is it mandatory? No. And I think that's what those Chancery cases are saying is it a mandatory result? No, but alone it can be sufficient. But that's what we have here as well. There are 3 other
Wait a minute,
facts.
alone it can be sufficient. You mean to say without supporting facts at all?
That's what the Martin Marietta case is, that the difference being it is
Martin Marietta
sufficient.
is susceptible to that reading, but in fact, there were facts there.
Oh,
And
and
the Chancery Court has thrice read it the way I'm suggesting.
I don't think they're inconsistent, actually. Just because something alone is sufficient doesn't mean that it's mandatory. But I would like to get to why this case also has other supporting facts, strong supporting facts. The first one.
But before you move on to that, Mr. Romano, I took you to be suggesting that you thought that Delaware law applies under an Erie analysis. I mean, the briefing doesn't really go into this, but isn't the question that we would have to conduct an analysis under Erie versus Tompkins to determine whether federal procedural rules apply or whether Delaware law applies on this matter?
That's a great point. We make a substantive law argument. The district court and the appellee are saying, no, it's procedural law, that what is irrelevant depends on circuit by circuit. I'm not sure you have to conduct that analysis because, as Judge Ginsburg says, doesn't say, but has raised, there are other facts here. So even under the Sontag analysis, the Smith-Buckley, the DC Circuit case that they cite and that the district court cite, there is a loss of customers. Mr. Clevinger testified at trial that he said 8 to 12 customers he took over. The invoices say 18 out of 15, but he took those customers. That's a violation of 5. There's no dispute that he started a competing company. That's the biggest issue here. That's paragraph 4.
The district court held that those are not incalculable damages, the ones flowing from loss of customers. That's monetary and wouldn't support a finding of irreparable harm. What's wrong there?
Correct. And that is an error. If this were one contract, and you can calculate, this isn't a breach of contract case. This isn't loss of contracts. This is loss of customer relationships that have, in each of which have indefinite revenue streams absent the interference. And what we have is interference, which is what the non-compete is intended to avoid. You are disrupting revenue streams. Yes, these were annual subscriptions, but absent his interference, this would have been and had been up until the interference, back to back to back, indefinite revenues. Those are not calculable at trial. What happens for 1 year they are, but if you're interfering with the relationship for an indefinite period of, we don't know when these relationships would have otherwise ended if they weren't interfered with. They could have gone on for 10 straight years. We won't be able to do that. That's speculative damages, and I'm not allowed to put on speculative damages at trial. So I think it's an error to say that these are monetizable injuries. They are in the very short term, but the relationship itself you can't monetize. It could be indefinite. It could go 20 years into the future, and we never will know because of the interference that the non-compete was designed to obstruct. Your Honor, I'm already at 10 minutes. I'd like to reserve the remainder of my time.
All right, we'll hear from Mr. Chase.
Good morning, Your Honors. Kenneth Chase for the appellees. This case presents a circumstance where the trial court's factual findings preclude a finding of irreparable harm, and therefore the trial court correctly denied the motion for a preliminary injunction. That is the case under a pre-winter standard. That is the case in a post-winter world, and that is dispositive of whether a preliminary injunction should be entered. As the court discussed during the argument of the appellant, the argument of whether a contractual stipulation is dispositive wasn't raised in the trial court below. So that issue wasn't raised, could have been raised, admitted that it had been available to have been raised, wasn't raised, and therefore isn't before the court. But even if it was, it's not sufficient. Even the Delaware courts have held that a contractual so-called stipulation is not mandatory. It does not divest a federal court of its equitable power to deny a motion for a preliminary injunction. This record contains findings that the trial court that are unchallenged. The appellant does not challenge any of the factual findings of the trial court, and those factual findings are completely dispositive. The findings are that the appellant has hundreds of customers. The appellant continued to gain customers. The appellant's business is about the same. There's no risk of the appellant's business imminently going out of business, and there's been essentially no change in the business at all. Those findings preclude, as the trial court held, a finding of irreparable harm as to economic damages. Moreover, in the trial court, the appellant agreed that as to loss of customers, those are quantifiable as monetary damages should they prevail at trial. They admitted that. That takes economic damages off the table.
Why isn't that just belt and suspenders? They're planning to try to calculate, but Mr. Romano makes an argument today that, you know, the indefiniteness going forward, the length of the customer relationship is a factor that interferes with the economic calculus.
Sure, Your Honor. And that is why it's not irreparable harm and imminent risk of irreparable harm, which is required under Rule 65. What they're saying is 20 years from now, perhaps there'll be some attrition problem, but that is the inverse of what is required for a preliminary injunction, which is imminent risk of irreparable harm. And they agreed that they stipulated, the court made a factual finding that they don't dispute that monetary damages calculated at trial would address the economic damages claim.
Did Mr. Clevinger solicit clients and customers using the contact information that he exported from his OCP work email?
That's a disputed fact, Your Honor, and that wasn't determined. None of the, what was striking about the appellant's brief is the lack of citations. All these assertions weren't in the opinion. Mr. Clevinger's so-called contacts that he downloaded are his own contacts, his professional contacts that he's had for 20 years. And so the notion that he downloaded the contacts, they're his contacts. They're his professional contacts.
Well, those are going to be issues for a trial court, but if you come in and you're a principal at a business and you know, render your contacts the customers of a business, there may be an issue whether they're still your contacts in that context. So the notion that telling customers that their service provider is shutting down is not incalculable damage to the service provider's reputation, in your view?
Certainly not, Your Honor. And that was addressed by the trial court judge, Judge Cobb. She held as to the reputation damages that there's not much in the record, that there's no evidence that the customers would migrate back. The assertion that there was a representation that the appellant's business is shutting down is actually a necessary assertion for the relief that they're seeking. But in fact, that's not what they testified to. They deny that the appellant's business is shutting down. Who knows? But then in their briefs, they say, well, all these costs might put the company out of business. So that renders the assertion by the allegation that an assertion by Mr. Clevinger was made as to the future of Advocacy Holdings, that renders it probably true, according to what they would actually have to show in this motion, which was denied. They didn't show it. Their principal testified. Unlike any of the other cases where there was some support for a finding of irreparable harm, they pled themselves and they admitted themselves out of it. That makes this case more clear than any of the other cases in the record, because not only is there an insufficient showing of irreparable harm, there is the factual findings, which are not challenged, prevent the court from making that finding. Addressing the pre-winter and post-winter standards. Under the pre-winter standard with City Fed 1995 case, the DC Circuit held that a finding that irreparable harm was not shown is sufficient to deny a motion for preliminary injunction. The court needs to go no further. That's binding precedent in the Third Circuit, the 10th Circuit, the 11th Circuit, and City Fed in the DC Circuit said, once the trial court determines that there's no irreparable harm, then what are we doing here? Why are the rest of the factors why do they need to be discussed? But even if they did need to be discussed, they were discussed. And if there's one factor that's zero, then the other factors are not applicable. Winter only raised the rigor of the standard, requiring an independent showing of irreparable harm. Some showing. The argument might be that a lower showing of irreparable harm might be sufficient if there was a higher showing of likelihood of success on the merits. There was no finding of a likelihood of success on the merits as to any breach of a non-compete. There was no finding as that. So that's a zero of likelihood of success on the merits. And then as to irreparable harm, there's also a zero in the record here. So,
it appears on the irreparable harm that the district judge applied federal law. If we think that Delaware law applies to or might apply to the standard for what constitutes irreparable harm, do we need to reverse and remand?
no,
Why not?
because Delaware law and DC Circuit law as to the issue of whether a so-called contractual stipulation constitutes irreparable harm are not inconsistent. Both bodies of law indicate that even if there was a contractual stipulation, which an argument they waived, but even if they hadn't, that's not binding on a federal court to,
What about the other inputs to irreparable harm?
those are also not established.
No, but I mean, what law applies to them? If Delaware law governs the entire irreparable harm element, and that wasn't recognized by the district court, do we need to?
Federal law, Your Honor, irreparable harm analysis is not part of a cause of action. As to likelihood of success on the merits, that's a state law issue. As to whether irreparable harm is shown to the degree that's required under Rule 65, that's under DC Circuit federal law precedent.
I'm not sure that it's dispositive for purposes of an Erie analysis, whether it's part of a cause of action. I think it's a much more nuanced.
It's absolutely
Analysis.
nuanced, Your Honor. It's apples and oranges and it's ships passing in the night. Whether it could be irreparable harm in Delaware is irrelevant because this contractual issue under Delaware law is as to the issue of likelihood of success on the merits. Irreparable harm is not a state law question under Federal Rule 65. They brought the case in federal court. They moved for an injunction under Federal Rule 65. For them to then say, wait a minute, Delaware law should control a federal judge sitting in a court of equity. There's no precedent for that at all. And they didn't cite a single federal case that supports that.
So that sounds more like a forfeiture argument than a substantive law argument.
Oh, well, it's forfeiture, but even if it wasn't forfeited, it is federal law that governs the standard under Rule 65.
Thank you.
Thank you, Your Honor.
Did Mr. Romano reserve any time for rebuttal? We'll give you 2.
Thank you, Your Honor. I just want to make 2 points here, and it goes to your Judge Pillars and Judge Ginsburg's points of stipulation versus stipulation plus facts that constitutes. There, again, like I said, there are 4 facts. There's the stipulation, which under the Marietta case says by itself is sufficient. There are 3 other facts that were established. The first was the loss of customer relationships through Mr. Clevenger's testimony and the invoices. The second, the trial court found, which is the theft and misuse of the proprietary information, the theft of the new website and implementation. The trial court found that fact. That is an established fact. And the third is the reputational damage, and counsel is right. There was, quote, not much in the record, but there was something. There was an affidavit from a client of ours that said that there was some chatter around whether they were confused and whether we were shutting down or not.
Wait a minute, was there a finding or not?
There was not a finding. There was, the trial court held that there was, quote, not much on reputational damage. Now, that's something. And it's something when there is proven customer relationships that were stolen. It's something when there is a found fact of theft and misuse of proprietary information.
There was the district judge did enter partial preliminary
Correct.
injunction with respect to the use of the website.
Correct. That was under
Is that not the relief relating to the harm that you were just discussing?
No, that was pursuant to the second cause of action, which was a breach of fiduciary duty. What we're trying to enforce here and what we think the district court erred on was that we were count 1, which is the breach of the non-compete. We're trying to enforce the non-compete, 3 provisions of it. One is that he can't even have or own a business that competes. He's established that he's done that. He can't solicit and steal customers, and he can't steal proprietary information. So that third piece is also under breach of contract.
The posture here is a little bit unusual in that we're many months down the road. You didn't seek expedition on this appeal.
No.
And there's been water under the bridge. Has any imminent harm likely to occur already occurred?
There was a lot of discussion about this. I have been dressed down in the past for seeking emergency relief when courts have said this isn't a life or death situation. The district court in this case, and our client testified, we're not on the brink of collapse. The second point I wanted to make was that it can't be that the linchpin of enforcement of a non-compete agreement is, are you on the brink of collapse? Coca-Cola would never be able to enforce a non-compete agreement. Also, the law upon which they rely for that is when there's only monetary damages. That's not what we're talking about here. We're talking about relationships and proprietary information and reputational damage here, though. So there's no, the answer to your question is we are not on the brink of collapse. We are headed that way, and we are prepared to move if we get there, but it doesn't seem right, justice at all, if we have to wait until we're about ready to go out of business before we enforce a non-compete against our former CEO.
Can I ask about maybe some overlap between the reputational injury and the monetary injury? Were the alleged misrepresentations confined only to only to the advocacy customers that Clevinger was soliciting? In other words, is Clevinger alleged to have misrepresented to anyone other than the advocacy customers he was soliciting?
There's nothing in the record to suggest that it was outside of that, but of course, the only context that we have in a short period of time are our own customers, and so we thought that was the most important thing. I don't know in real life if that's the case, but there's nothing in the record that suggests that Clevinger was, other than on his website to the world at large that he was contacting non-customers to spread rumors about that. Thank you very much.
Thank you. Case is submitted.
Case number 23-1050. Cory Smith, appellant versus Commissioner of Internal Revenue. Ms. Farmer for the appellant, Mr. Wasserman for the appellee, Mr. Harris, amicus curiae.
Ms. Farmer, you may proceed when you're ready.
May it please the court. I stand here before you today representing Mr. Cory Smith, who seeks to disavow his legal positions. He previously advanced these positions by being highly influenced by Mr. John Castro, who, as you are probably aware, has been convicted of fraud. And Mr. Castro represented himself out as a tax attorney. He was never licensed to practice law. My client and myself are aware that this is a very unusual situation and that you're really not supposed to come and change your position at this time. But he asked for the court to take into consideration that the only reason he advanced these arguments was Mr. Castro's contract with him that required him to litigate this issue to his satisfaction to receive any of the fees back.
Ms. Farmer, I want to thank you for being here and also thank you for the candor and the transparency. When you say that Mr. Smith disavows, it seems to me like that's similar to saying that Mr. Smith is abandoning the arguments that he made.
Yes, sir.
And I think my question for the government is going to be, why wouldn't we just issue a judgment saying the arguments have been abandoned, they're therefore forfeited, and that's the end of the case. I understand the government won't kind of get the advisory opinion from us that they might wish to use in future cases, but that's not really our role. That sound right to you?
We don't ask that happen. We do really actually would also stand with the government that there probably is purpose in having this judgment because there are so many pending cases and other people who have been affected by Mr. Castro. So we're not asking for there not to be a ruling in this matter. If there's any possible way for there to be one, there's been an amicus. This has gone so far. Everybody has expended time, finances, to get it to this point. So whatever works best for everyone is good.
So you're basically asking to voluntarily dismiss the appeal.
Yes, and we understand that the appeal was requested to be dismissed and the court rightfully denied that because of the advancement of the case and the matters pending before it. And so we don't disagree with that and think that that was the right decision because going back through and seeing how many people have been fraudulently impacted by Mr. Castro and are still in litigation at this point. And the way Mr. Castro is handling these cases, having the clients go pro se and filing these himself, he logs into their accounts and files them.
Wait, what?
Yes. He logs into their Pacer account and files the pleadings.
Under their login identification?
Yes. Yeah. I just found that out 2 days ago. So as soon as Mr. Castro realized he's in Australia, so he's not up to date with everything going on here. And he did not actually find out that Mr. Castro was indicted until Mr. Wasserman put an objection to Mr. Castro's motion for leave to file an amicus brief. So after that point, he tried to remove himself from this litigation, and that's why he hired me and my firm to help him do that.
All right. Thank you.
Thank you.
Good morning, and may it please the court. Carl Wasserman on behalf of the commissioner. I want to address Judge Walker's question to Ms. Farmer. Mr. Smith did in fact put in a motion to withdraw this appeal. We objected to that. It was not stipulated. And there are at least 14 other cases that are pending in the court, in the tax court, that are directly stayed because of this case. Mr. Smith was the first case to be filed promoting the positions that he took in this case. And although I understand that he now has abandoned these arguments, I mean, he does have affidavits in this case. There is a record in this case, and many of the other cases in the tax court are going to depend on this, what the court decides in this case.
Mr. Wasserman, I understand it, and I don't blame you for wanting us to do more than dismiss the appeal on the grounds either that the arguments have been abandoned or that, but you know, the adversarial process exists for a reason. The idea, I know you know this, but the idea is that we will do a better job in figuring out the right answer to a legal question if there's adversarial presentation. I don't think I've ever seen a case where there's less adversarial presentation, especially after Ms. Farmer's very thoughtful, you know, comments and understandable comments. And you know, I don't blame Mr. Smith for being mad at Mr. Castro, but in part for the reason that you want us to reach the merits, I'm cautious to reach the merits because this will affect, if we issue a published opinion reaching the merits, this will control future cases, and those future cases may wish to present adversarial, you know, may wish to have an adversarial presentation, and we might get the answer wrong. We might be more likely to get the answer wrong now than we would later if a later case has adversarial presentation.
I understand, Judge. Of course, my friend, your own appointed attorney, has also done a lot of work in this case.
He's not against you either.
As well, he should not be, because the government is correct in this case. I do want to emphasize something, and I think it is important. 40 years of work has gone into this Pine Gap arrangement. It is carefully thought out between the IRS and the Australian tax authorities. It was designed to provide American taxpayers who work smack in the middle of Australia in the Pine Gap facility with a tax benefit. It provides them with simply by filing a closing agreement. This was Mr. Smith's closing agreement. It's 4 pages. By filing that closing agreement, you get the benefit of American taxes, which are lower than Australian taxes, U.S. withholding. You simply say, I will not claim this foreign earned income exclusion. You don't have to pay Australian taxes. They don't take Australian withholding from you. They don't, and you don't even have to file a tax return. So this 4 pages does a lot of work. I would tell you, Your Honor, that there are hundreds of these agreements that are currently in use. You can get off the website.
My understanding has been all those decades that, well, not all those decades, but it's been a long time and it's worked. And that Mr. Castro, if I'm understanding correctly, is behind not only Mr. Smith's now terminated effort to challenge it, and behind the efforts of the other cases that you mentioned that are coming up through the tax court?
Your Honor, as far as I know, there are other petitioners in the tax court who have independent counsel. There are some who may be simply pro se. I do know that, as far as to my knowledge, all of those cases were stayed pending Smith. Now, there was one other case that was in the Court of Federal Claims, and we filed a notice of recent decision with you about that case.
And I wonder if it's appropriate if the IRS is in touch with people to notify them of what's gone on with the proponent of the theory on which they now rely.
Well, I think, as you said, Your Honor, this program has worked. And I think that I'm hoping that, again, depending on whether or not this court does issue a decision or waits for another possible case, that the word will get out that these agreements, just as Judge Toro, and he wrote a very thoughtful decision here, he said it was beyond question, those are his words, that these agreements were properly authorized by the IRS, that they were not improperly obtained by the IRS. It's a small agreement, but it does a lot of work. And I think even though as I said, Mr. Smith has conceded that his closing agreements were binding, and I think we're going to hear that from the amicus, we'll take the same position. I understand everyone's singing from the same hymnal here, but at the same time, if there is a live controversy, and again, the court did not deny the motion the court did not grant Mr. Smith's motion to withdraw. I think this would be a good opportunity for the court to rule. I'd be happy to answer any questions if you have any.
Are all, if I recall correctly, in this case, the tax was paid and the taxpayer is seeking a refund, is that correct?
Well, no, Your Honor. He received a refund because
Okay.
exactly. Now the refund was frozen, but he received a refund because what you do is when you file your tax returns, if you live in a foreign country and you claim the exclusion, then they would see that you have this Section 911 that we've briefed, then you would deduct that from your income. What Mr. Smith and all of the others are required to do is file a copy of a closing agreement saying, I'm not allowed to take the waiver. So when the return was processed by the service, they saw that he claimed this exclusion, and they reduced his income down to zero and refunded him the money.
They refunded the money, but it's frozen? I mean,
Correct. In other words,
so you have access to it,
that's correct.
and it will now be, the IRS will be made whole in light of Mr. Smith's current position with respect to Mr. Smith's case.
That is my understanding.
Is that true of all the cases? All the 14?
I believe so, because if I understand correctly, no one who filed a tax return claiming, they all claimed this exemption, and none of them filed a copy of their closing agreement, which would have indicated to anyone who examined their returns that they were not entitled to take.
And all refunds, if there were refunds, have been frozen.
As far as I know, I can't say for sure, Your Honor. I don't believe they were issued, because I believe one of the requirements was that they were frozen, but I don't know for a fact. But I know refunds were issued.
Okay, I take one more shot and ask for your help, just as I think through the question that I started out with. We don't have jurisdiction to issue an advisory opinion. I'm not saying that we lack jurisdiction. I'm not saying that we're in that place, but it feels a lot like you're asking for an advisory opinion. And can you do anything to assuage that concern?
Well, Your Honor, I mean, the rules do say that if you're going to dismiss a case at this point, that it be stipulated. And I understand we can't stop someone from coming up here and saying that they abandoned the case. That said, again, the fact that there are, affidavits, does he say that I didn't mean what I said in my affidavits? Those are sworn. Does he say that? As far as I know, he's not saying I'm lying. So he put things in dispute. The case is fully briefed. I hear your point, Your Honor.
But if he's abandoning his claims, I take it that the service would not have any basis on which to refuse to stipulate, any substantive basis. I mean, I understand your interest in terms of the development of the law, but in terms of the concrete interest in this dispute, I think it's hard to see what.
Let me offer one other possibility. When people take positions for the service, sometimes there are penalties for negligence. I accidentally, I did the wrong thing. Sometimes there are willful penalties that a person should know better. And I think this might be an opportunity that people should be in a position where they do know better. Penalties may be on the line, whether it's in this case or future cases, that I think would strengthen the service's position if this court does render a decision in the government's favor.
If they have not been sought, then that would have to, I think those issues would have to arise when and if they were sought.
Yeah, and as far as I know, I believe there are such penalties in some of the tax cases that are currently being stayed. And as I said, I think that would be one other sort of hook if the court were going to render a decision. Thank you, Your Honor.
None's been assessed in this case,
I'm sorry?
but no penalty's been assessed.
Well,
this case.
in this case, Your Honor, because I think, like I said, we froze his refund, so we have it back in this case. I was simply saying that in future cases, if a decision comes from this court upholding these agreements, then if someone else will come along and say, I had the right to do this, it would strengthen service's position to know that there is binding law that these agreements are valid. Thank you, Your Honor.
Yeah. Mr. Harris, we invited you to participate.
Yes, good morning, Your Honors.
Party seems to be going south.
Well, Your Honors, I'm happy to address whatever issues the court would find useful, but I'll start with yours, Judge Walker, about the adversarialness of the proceeding. Now, obviously, I'm cognizant of the concern expressed by the court that we lack adversarial proceedings here. And I think there's two questions under that, with respect to that, before getting to the merits. And obviously, we didn't brief this, but just to raise them for the court. One is an Article 3 question: does the court have jurisdiction? And here, Mr. Smith is aggrieved by a judgment below issued by the tax court. And in terms of, pure adversarialness, does he have an interest in reversing that judgment? The answer is probably yes for purposes of Article 3, although, we'd be happy to file a letter brief to that effect if the court would find it useful. Now, the broader issue is there been a concrete presentation of adversarialness for the issues in the case? We think the answer is no, given Mr. Smith's arguments here today. And so the question is, under Federal Rule of Appellate Procedure 42, whether this court should voluntarily dismiss the appeal or issue an order dismissing the appeal, deeming Mr. Smith's arguments forfeited. There are circumstances in which federal courts of appeal have refused to dismiss cases under Rule 42, but those circumstances don't appear to apply readily to the circumstances here. I'll just direct the court's attention for reference to United States versus State of Washington Department of Fisheries. That's the Ninth Circuit case from 1978 at 573 F. 2nd 1117. And there, the court, then Judge Kennedy, was expressing a concern about gamesmanship. I mean, what you don't want is a party to appear at oral argument, see which way a court of appeals is going, and then abandon claims in order to obtain a ruling that, in order to avoid obtaining a ruling that would steer the law in a particular direction.
And I take that point. I understand it up to a point. It is pretty common or argument to ask for concessions, and when those concessions are made, I think we view that as a significant purpose of the oral argument. And here, not only has one argument been conceded, but all of the arguments have been conceded.
I hear that, Your Honor. I think this is an unusual situation that goes beyond just conceding one point or one argument that would help sharpen the legal issues before the court. And here, Mr. Smith has obviously abandoned all of his arguments and doesn't appear to seek reversal of the judgment.
I might be less worried about going as far as the government wants us to go if some of the legal issues weren't at least a little bit tricky. I mean, the question of whether scienter is part of what we analyze if there's a misrepresentation in an agreement like this, it seems not incredibly easy legal question, and it seems like it could have pretty far-reaching consequences. And hard legal questions with far-reaching consequences are exactly the kind of questions that we benefit the most from a true adversarial presentation.
Of course, agreed, Your Honor. And I think obviously here, the legal questions were complicated enough to warrant the appointment of a friend of the court. So, that's maybe one more point in favor of waiting for a case in which the legal issues are sharpened and presented.
Do you think we could use your very nice brief in a future case that raises this issue, would the court be able to, I mean, I think the answer is yes, we could read it, we could consider it. We wouldn't have to appoint you or someone else all over again to say the exact same thing.
I think that's probably right. And I'll represent that I'm happy to appear again if the court would find it useful to speak to the merits issues in the briefs.
We appreciate the offer, and I assume also that Mr. Wasserman will be able to cite to this brief as a document of public record if and when these other mentioned appeals from the tax court are pursued.
I think that's right, Judge Pillard. And the only thing I would say is on the misrepresentation point, coming back to your point, Judge Walker, there's, obviously 3 different paths to resolving the misrepresentation issue before the court. One is the tax court's route of saying statements of foreign law cannot be statements of fact. One is the government's proposed test, which would impose an intent requirement. As we point out in our brief, there are cases going back to the 1930s, Ingram versus Commissioner, that impose that intent requirement. But it's not entirely clear how you get to that from the statutory text. And so we've proposed a third route, which is that a statement of law can be a misrepresentation of fact so long as it's clearly and demonstrably erroneous, given that statements of law are sort of like opinions. It's the United States is making a representation that it believes foreign law to mean a certain thing. And in that context, we think in order for that to rise to a misrepresentation, there needs to be some showing that reasonable minds couldn't differ about the meaning of law. And after all, closing agreements are supposed to settle uncertainty about the meaning of law. So that's our position.
Maybe one thing that we might do if we had a case before us is agree with your powerful advocacy and actually Mr. Smith's advocacy that statements of foreign law are statements of fact, and see what the tax court, as the expert in the standards for Cmsnr in this context, would say in light of that. So it may not just be our court that could have the benefit of your brief, but perhaps the tax court, if it has any more of these cases to process. But I know you were appointed by the court, and we're very appreciative of you and your colleague, Ms. Kansra, being here today. Your brief was very able, and it's a generous assistance to the court. So we thank you for that.
Thank you, Your Honors. Our pleasure.
All right, and I trust that Ms. Farmer, nothing further?
I will say, I don't think I said it for rebuttal, but there were penalties in this case. So for 2 years, he did receive a refund, and the contingency agreement was 50% of the refund paid to Mr. Castro. He has since made the IRS whole. He's paid all penalties. So there are penalties and interest. He's paid all of those. And then the last year was frozen. 2 more years after that are in a different matter, and they're still in the tax court, but he's paid all of those, and they are drawing up a stipulation to end that also. So,
Thank you.
thank you.
The case is submitted.
Case number 21-5275. NS, individually and on behalf of all others similarly situated, versus Robert A. Dixon, United States Marshal, District of Columbia Superior Court, in his official capacity, appellant. Ms. Pudin for the appellant, Mr. Gonen for the appellee.
Good morning, Your Honors. Elissa Feudum on behalf of the appellant, the United States. The Attorney General acted well within his statutory authority when he delegated to the U.S. Marshals the powers and duties of immigration officers, including the power to briefly hold class members pursuant to a detainer and an administrative warrant. The district court's order to the contrary should be overturned, and the injunction vacated because it violates 8 USC 1252 F1 and incorrectly found the delegation to be unlawful. ICE relies upon cooperation from the U.S. Marshal Service to carry out its duties and to arrest and detain certain removable non-citizens as directed by Congress under sections 1226 and 1231 of the INA.
But let me
When
ask you, Ms. Budum, if the Homeland Security Act transferred immigration arrest and detention authority to the Secretary of Homeland Security, how is it that power could live on in the marshals under the authority of the Attorney General when the Attorney General no longer has the authority to delegate?
Because the HSA contained a savings provision for completed actions, and Congress defined completed actions, and its definition was broad to include, I believe it said, all grants, orders, and privileges.
Doesn't refer to delegations.
It doesn't. It
And
doesn't.
This was, you're relying, I take it, on the 2002 order, the 1996 order. Those are, as a formal matter, orders, but one typically thinks of an order as something that could be a completed administrative action, whereas the nature of the delegation as you are relying on it is as something ongoing. So for example, who are the marshals supervised by in the exercise of the authority that you contend they have under the 2002 order? The Attorney General?
Well, as the court noted, the immigration powers that were previously vested in the Attorney General were transferred to the Department of Homeland Security, and the marshals are not a subcomponent agency of the Department of Homeland Security.
Right, so they're not supervised in this activity by the Secretary of Homeland Security?
I wouldn't describe it as supervision, no. I would
And they're not
describe,
supervised in this role by the Attorney General because the Attorney General's authority has all rolled over to the Secretary of Homeland Security.
yeah, and I would say that it's not a function of supervision, but one of cooperation between ICE and the U.S. Marshal Service, which is a law enforcement agency, the oldest law enforcement agency in this country. And I would draw the court's attention to the fact, I know you've focused on the word orders, but I would draw the court's attention to the word grants and privileges, which are also preserved by the completed administrative actions. And I would submit that the delegations are a grant and that they bestow upon the U.S. Marshals a privilege, and that as a result, the HSA is not an impediment to the powers that were bestowed.
Are you aware whether there are any other delegations of authority that were made before the 2003, before the Homeland Security Act, that might similarly be grandfathered and be continuing?
I'd have to look at that. I'm not aware off the top of my head. If there were, I would suspect that there probably are, just by the time frame that we're talking about and the fact that your question would encompass, decades of administrative action. My guess would be that there is, but I can't point.
There's a delegation from the Attorney General to the DAC, isn't there?
Yes, that's correct. Yeah, that would be an example. Thank you. Yes, I mean, I would have to imagine that the answer would be yes. I mean, I know that there was an argument made by my friends regarding if this delegation, that talked about this delegation with respect to the delegation to the deputy and whether it continues to live on. And our position, as we expressed in our papers, is that there is a difference between a specific delegation, which is governed by terms, and a catch-all designation, which says whatever powers I have, you have too. And I think that there is a distinction to be drawn between a delegation of such generality of whatever powers I have, you have too, and a specific delegation like the one we have here, which encompasses specific terms.
It's not your position. I mean, there was an amicus brief filed, but I take it it's not your position that without the 2002 order and the 1996 order, that the marshals are authorized to carry out the function that they carried out in this case. They're not authorized to detain people who have been released from a court.
We did not appeal on that basis. And so I concede that we've waived those arguments here. I think
Did you make that argument in the district court?
the argument was made at the district court, and I do think that the argument could still be made and that there is validity to the notion that the U.S. Marshals have the authority pursuant to their enabling statutes to act upon these warrants. There's all sorts. I mean, there's retake warrants, there's parole warrants, there's military absconsion warrants, all of which are administrative warrants that the marshals have traditionally been able to execute upon for decades. And so I think there are arguments that can be made, but I will acknowledge that we did make a decision not to pursue that basis of appeal here.
This is an unusual kind of warrant, and maybe the military warrants that you're talking about are also civil, but marshals typically don't have authority to execute non-criminal warrants. Is that correct?
Well, I take your point that their enabling statutes speak to their authority to arrest for felonies committed in their presence, as well as certain felonies for which they have probable cause to believe were committed. But I think an argument could be made that absent a statute that specifically divests them of the power to cooperate with a fellow law enforcement agency such as ICE, particularly in view of other statutes which provide for cooperation with ICE and between law enforcement agencies, that there are arguments that could be made that notwithstanding I think it's section 566 that you're referring to, that notwithstanding that apparent limitation, that absent a particular statement precluding the marshals from such cooperation, that it would exist. But again, that's not an argument that we preserve for this appeal. So I don't make that argument here today.
I mean, to the extent that the marshals are being treated under the delegation orders that you do rely on as, in effect, immigration officers, isn't there a further problem that immigration officers, and I think this is true when state officials are delegated under 566 or when to cooperate, I may be mixing up my authorities, but when there is a statute that says, state officials can work with INS, isn't there a requirement that they also have training to be sort of de facto immigration officers? And there's no assertion that there's been any training here.
Well, I think it's interesting because I think the section that you're referring to is 1357 G2 as well as G10. And I will note that I was rereading my reply brief in this case and I miscited the statute as I think 1101 in one instance. So apologies for that. But I believe that that's the statute you're referring to.
Thank you.
And I think there's 2 points to be made here. On the one hand, you have section G2, which says that when there is a contract-like agreement between state officials and the federal government for state officials to act in a contractual capacity as immigration officers, they have to have certain training. And I think from that, you can say, look, Congress knew how to talk about training. If Congress wanted training, they knew the words and they knew how to say it.
I
Because
thought that was in the reg, not in the statute.
I believe that if you look at the statute itself for 1352, where it talks about with respect to, I think it's 1357 G2. I believe it is in the actual statute, Your Honor. If you give me a minute, I'll find that. But yeah, it's 1357 G2. It's in the statute, Your Honor, not the reg. I think you're thinking of the regulation where it speaks to certain individuals that have to have.
87.5.
Right. So that's speaking to federal individuals who act as immigration officers under the regulation. So individuals that would have to have certain training. I think what Judge Pillard is asking about is 1357 G2, which is the statute, and it speaks to training that certain state officials have to have. And so my point was that when Congress wanted to enforce or require certain training, it knew how to say that. And it did not say anything about that when it issued, for example, other delegatory powers to the Attorney General to make delegations speaking to that. But I would also make one other point to your point, Judge Pillard. If you look further down in 1357 to section G10, that's a provision that says that state employees outside of this, quasi-contractual relationship spoken to in G2. It says that state employees may cooperate with ICE in the apprehension and detention of removable non-citizens. And it doesn't say anything about training there. So it seems like what Congress may have been saying is if you have some sort of contractual relationship, then there has to be this training. But if you're just talking about cooperation.
But that may be passing information, for example. That does not at all imply that a state officer who does not have knowledge of and adhere to federal law relating to functions of these officers or employees could, for example, serve an I-200 and make an arrest. I mean, I think the same statute seems to suggest otherwise. If you're going to act like an immigration officer in that regard, you'd be subject to the regulations that Judge Ginsburg mentioned.
I think, and I apologize, I don't have the full statute in front of me, but I think 1357 G10 does speak to apprehension and detention, or at least alludes to that. And so I think that there is this notion that Congress
Communicate with the Attorney General regarding, this is 10A, regarding the immigration status of any individual, including reporting knowledge that a particular alien is not lawfully present in the United States, or otherwise to cooperate with the Attorney General in the identification, apprehension, detention, or removal of aliens not lawfully present, which one way of reading that is that you're cooperating by helping the Attorney General to apprehend, or the Attorney General, the Secretary of Homeland Security's staff to actually do the apprehending. I mean, that would be a way to
I think, I take your point.
reconcile.
That would be one way to read it. I think another way to read it would be that it includes references to apprehension and detention. But again, that has to do with state officers. It's not
Right.
what I'm briefing. And I didn't remember to say to you that I was saving time for rebuttal, although I did say it to your,
But G10
yeah.
also relates, at least to state or political subdivisions. right?
Yeah, state.
What's with them? So how does that, what are you saying about that that reflects in any way on the training requirement for federal, for the Marshal Service?
I was just making the point, Your Honor, that it seems that Congress knew how to speak to training. And so when you look at, for example, 1226, and Congress speaks to a warrant of the Attorney General, and then if you look at the regulation for 236.1, which is the regulation implementing section 1226 that identifies that warrant of the Attorney General as the I-200, which is the warrant in this case, nowhere in section 1226 does Congress say, and upon executing these warrants, there has to be some sort of training. And if you look at 1101A18, where Congress defined immigration officer, Congress did so and said it could be somebody, an employee or class of employees designated individually or by regulation. So there's the word "or" there. And I think if Congress wanted to say, but in case one, there has to be training, I would just point to 1367 and say, look, Congress knew how to talk about training, and there's no indication that Congress was doing so. I had some other points, but perhaps I should save my 1 minute for rebuttal, Your Honor.
Our practice in this court is that we will give you time as long as we find it useful to keep asking.
Well, then thank you. I appreciate that.
Hearing from you, so it tends to be a good sign if we're finding your colloquy with you useful. And we will endeavor to give you also some time for rebuttal. So would the marshals be able, on your theory, to make the arrests and detentions in question if there were no I-200 forms involved?
I think that's a closer question. Our position would be yes, that the detainer itself provides probable cause. And I think that there could be arguments to be made that under common law doctrines like fellow officer rule and such, that there is authority for the marshals to hold somebody also under law that exists concerning wants and holds, which is other areas that we did brief before the district court on summary judgment. But to be fair, we did not preserve those arguments for appeal. And so I'm not making those arguments here.
So the I-200 is directed at immigration officers?
Yes.
That are authorized under 1226 or 1357, associated regulations. And none of those regulations authorize the marshals to serve an I-200.
I think that that's right. I mean, our position is that the 2002 delegation, and again, we can talk about the 1996 and the 2002. I think the 2002 can be viewed standing alone. I don't think it depends upon the 1996 delegation. So just viewing the 2002 delegation on its own, it imbues the marshals with the authority to act as immigration officers. And when you talk about, well, was that authority permissive? I think you can look back at both, you can look at 510, Section 510 or 1103A4 that gave the Attorney General the authority to make delegations. And when you look at the definition that Congress assigned to immigration officer in 1101A18, it says that position can be bestowed either by regulation or there's a parallel track, and that parallel track is delegation. And so that's the track that we come to the court saying that these marshals were imbued with this authority.
And when it's just the ICE that's doing it, is an I-200 something that is considered to have to be personally served?
ICE does serve the I-200, and that is by regulation a requirement, I believe, on ICE. In this case, I believe we did file the I-200, and there is a service signature on it. It's the ICE officer that I believe serves that, not the U.S. Marshal.
And that was attached to a brief in this court?
Yeah, I concede it's perhaps not the best look of all time, but the appellees want to frame the issue in this court as whether or not the U.S. Marshals had authority to detain NS and the other class members without a warrant. But that's not the issue here because it was never the issue below. Now, I wish I could tell you why that I-200 was not included within the appendix below. I didn't handle the appendix below. Unfortunately, the attorney who did is no longer with the U.S. Attorney's Office, and the individual who certified the administrative record is no longer with the Marshal Service. And even if I spoke to them, I couldn't reveal privileged communication. So I can't tell you that, but I have to believe that it was an oversight or an accident at some point in time. There was never a dispute below as to whether or not there was an I-200. The appellees argued repeatedly and successfully to the district court that an I-200 is not a true warrant. The district court accepted that position. We obviously disagree with that, and there's cases out there like Able that we've cited to in support of our disagreement. But the district court accepted that there was an I-200. The district court, in writing about section .111, noted that the I-200 is not addressed to the U.S. Marshals. It's addressed to immigration officers. There was a whole, there was briefing on that. So I really think this ship has sailed in terms of the waiver doctrine, in terms of whether or not we should be debating now whether or not there was an I-200. But
In your brief on this, you invoked the presumption of regularity.
Yes.
Nothing what that you've just said, but just the presumption.
I mean, we did invoke the presumption of regularity. I think we also noted that there was a waiver issue below that, had it been raised below that, look, this document is missing from the record, it would have been fixed. It was never raised below. I can't speak to why. I wish I had more information on that myself. It's one of the first things I noticed about the case.
Your point about the district court proceeding as though this were not an issue at all.
Yes. I believe I did say that in the papers, that the district court proceeded as if it was not an issue, because when we talked in the brief about section .111, I think we addressed the fact that the district court said that the I-200 is not, it's not addressed to the marshals, and the district court discussed the fact that it's not a true warrant because it's an administrative warrant and not a judicial warrant. And then we cited Able, and we said that that's not correct, respectfully, to the district court. And so I think the issue, I think we did say below that the district court accepted that there was an I-200 in this case.
Whether warranted or not, I have a question about the training. In your brief, you say nothing in the language of the regulation 287.5 purports to award exclusive authority over these arrested detentions to the listed agents and officers. But isn't that answered by the regulation 236.1B1, which says a warrant of arrest may be served only by those immigration officers listed in 287.5B, and that list does not include United States Marshals.
Yeah, and I take your point, and I think the issue there is that, at the time that the Attorney General delegated authority to the INS to issue regulations, like the regulation you're talking about in this case, he reserved for himself all his powers, and that's at 23 Fed Reg 9117-9118. And that's back in 1958. And he noted that the delegation to the INS was made without divesting the Attorney General of any of his powers, privileges, or duties under the immigration and naturalization laws. And that includes by congressional approval, the right to make delegations under Section 1103A4 and 28 USC 510 and USC 1101A18. And so I think if you took the argument regarding 236 to its logical conclusion, then the Attorney General could never delegate authority to make the immigration arrests to anyone, and it would sort of nullify the initial reservation of rights.
Well, then I think your argument is that the orders, 1996 and 2002, rendered the marshals for these purposes immigration officers. And that would then empower them under these regulations to make the arrest. But then you have the problem that they're not trained as immigration officers who do this must be trained.
Well, I think, and I take that point, and that's an argument, my
Either they're
friends.
marshals and they're different, or which they're not authorized to do these activities, or they're denominated for limited purposes immigration officers, in which case one would think they have to act as immigration officers, just like the state officials have to act.
Well, to the state official point, I think there are circumstances where they have to undergo the training and others where they don't. But to your point, I think our argument is that there's nothing inherently inconsistent about having regulations apply to people who are subject to those regulations. These are INS regulations. The marshals are not a part of the INS, and that there's nothing inconsistent.
But that's a problem for you, not a benefit. So you effectively, let me step back and ask you, without grandfathering the authorities granted by the 1996 and 2002 orders of the attorneys general, how would the government go about accomplishing this task without posting an ICE officer at the Superior Court? What is the authority, if this were to happen today, as opposed to through pre-Homeland Security Act delegation? How would you set this up?
I'm not sure I understand the question. So when ICE learns that an individual, and stop me if I'm not answering the question you're asking, but when ICE learns that an individual is going to be released from custody, they would send somebody in a perfect world to the courthouse and wait for them. The reality of this world is that there's not enough ICE officers, particularly in certain districts more than others, to stand outside of courthouses all day, particularly with delays that might be occasioned by someone's trial calendar ran long or other realities of the courthouse, and then they would pick someone up. And the risk that you have.
No, I understand that. And it's true with state courts generally. I mean, DC is a special case, state, federal, but generally it's true. And there is some provision in statute for working that through. So assume that we rule against you here. What next?
I mean, I think if you ruled against us.
The Attorney General issue a new order?
Yeah, I mean.
Have to come from the Secretary of Homeland Security?
I think it would have.
Deputizing a marshal to,
I think if you ruled against us, it would have to most likely, and I don't want to bind us, but I believe it would most likely have to come from the Secretary of Homeland Security. And I do think that could probably be fixed fairly simply with a delegation, which perhaps addresses some of the concerns raised here.
If the disagreement with you relates to the training, then why would it not be an option for the Attorney General to provide the training, or for someone to provide the training?
It might be. I mean, those decisions would be above my pay grade, Judge Ginsburg. I suppose one option would be to provide the training if that were the issue. I suppose another option would be to correct or to modify the order, because as you know, the court below had issues with Chenery, which I haven't touched upon and we don't think is an issue. But if if that was something that this court found problematic, again, that would be something else that then would have to be addressed outside of just the training. So I mean, I do think that if you rule against us, it's not that the issue can't be fixed, but that the government has made a choice to defend what's taken place and that there's no necessity to do anything beyond stand behind the order that was issued. I did, sorry.
No, go ahead.
I was just going to say, I did want to just say one last thing to Judge Pillard, which was that we view nothing inconsistent about having a delegation that can run parallel to regulation, such that individuals can be designated by delegation who may not be susceptible or encumbered by or required to abide by training requirements, and other individuals who are designated by regulation might have to be. And again, we look to 1101A18. So I was just going to close the loop on that, but Judge Walker.
I asked you about 1252F1.
Yes.
Particularly what you had mentioned, and we haven't
Yeah.
really discussed, that the marshals are not mentioned in section 1226 or 1231 or the implementing regulations. And I just wonder what your theory is of how the injunction in this case enjoins or restrains operation of those statutes or any of the other statutes within the series that is referenced in 1252F1.
Well, in Ailman-Gonzalez, the Supreme Court made clear that when the statute talks about the operation of the covered provisions, it's referring to not just the covered provisions themselves, but how the government chooses to carry them out. And so here, the covered provision that we would cite to would be section 1226. 1226 references in its text on a warrant of the Attorney General. The regulation makes clear that that warrant is the I-200. The way that ICE carries out and implements section 1226 is with reliance upon the U.S. Marshals. And again, it's a necessary reliance based on just the reality of how many ICE officers there are and what's necessary to pick someone up. Not only that, you have concerns about safety. The difference between picking up an individual from the custody of a marshal.
We have no reason to question the policy reasons. But so on your view of section 1252F1, it bars class-wide injunctive relief or non-individual injunctive relief against any agency purporting to act pursuant to the specified INA provision. So if the National Park Service rangers began making immigration arrests and detentions and said, hey, no injunction against us, the district court, on your theory, would be precluded from entering an injunction to stop that on a non-individual basis.
I think it would be a closer question if it was the National Park Service, if it was the EPA, if it was the post office, but that's not this case. I mean, in this case.
So give me a principle why that would be different.
I mean, as a principle, I think yes. If ICE were, for some strange reason, relying upon the New York Forest Service or the Postal Service to do this, and that was their policy, and they could articulate a reason why that could possibly make sense, then yes, 1252F would bar it as a principle. Do I think it presents more difficult questions? Yes, I think it presents more difficult questions.
Because if it's ultra vires or it's some kind of exception to the remedial strip that 1252F1, I mean, I'm really seeking your help here because I read Ailman-Gonzalez also to be very broad, and the colloquy between the majority and the dissent about, the operation of the law, where the dissent says the operation of the law has to be like the law, not illegal. And the majority says, no, laws can be operated illegally just like vehicles can be, which to me would suggest that if the National Park Service is operating this statute, that a court could not enjoin it. But that feels like a pretty strong medicine.
Yeah, I mean, as you said, the majority in Ailman-Gonzalez says that the prohibition from 1252F applies to any action that requires the government to refrain from actions that in the government's view are allowed. And that means that if the government is misinterpreting and misapplying a statutory provision, it's still covered by the ambit of 1252F. And that means that it's not limited to laws as properly interpreted. And so based on the black letter, of Ailman-Gonzalez, I would say, yes, there is an argument, a strong argument, probably the stronger argument to be made that the EPA or the Park Service could be protected by it if it is cooperating, with ICE under the covered provisions. I say it's a closer question, not because I am able to draw for you what the limiting principle is, but just because, the gut reaction is, oh, that seems a little weird. Why would the Park Service be doing that? That's why I say it's a closer question, but it's not this case. And so I don't think that we need to find what the ends of the limiting principle are. In this case, the cooperation, I think, does make sense between two different law enforcement agencies. 1226 talks about a warrant of the Attorney General. This is how ICE implements Section 1226, and the court's order enjoins it.
Plaintiffs sought vacatur and declaratory judgment as well. So if we were to agree with you on the applicability of 1252F1, the appropriate course would be to remand for the district court to consider whether there's remaining relief.
I think I would disagree with that. First, I would say, and now I'm afraid that I'm wrong, but I don't believe that the plaintiffs did seek vacatur. I believe they also sought declaratory relief. I could be mistaken, but I don't recall there being vacatur. But to speak to both points regardless, I would first say vacatur is not really a remedy that makes sense in this case, because when you talk about vacatur, you're typically talking about a policy, rulemaking, or adjudicatory action. I mean, here, the only thing that could possibly be vacated would be the 2002 and 1996 orders. And if that could be vacated through the action of a single member of any individual person, it sort of raises a question of what purpose does class certification serve? And so our position would be that vacatur is not available, and it also wouldn't be available for the reasons that were discussed, I believe, when the Solicitor General was arguing.
Declaratory relief.
What's that?
What about declaratory relief?
I think declaratory relief that functions like an injunction would still be barred by Section 1252. I think it's harder to draw where that line is.
I mean, I think the government's position in the supplemental briefing in maybe Arizona v. Biden might be getting the state wrong there. But the one that was a couple of weeks after Alaman Gonzalez, I think they said 1252 F1 blocks out injunctions and it blocks out vacatur, but it doesn't block out most declaratory relief.
I think that's right, that it doesn't block out most declaratory relief. I think the government's line, the Solicitor General's position would be that there is probably room for certain declaratory judgments, and there probably isn't room for others if a declaratory judgment acts like an injunction. And I would just point the court to Hamama v. Aducci, which is 912 F3rd 869, which is a Sixth Circuit 2018 opinion by Judge Sutton. We don't have Supreme Court law on this with respect to the declaratory judgment. I think that there is a line to be drawn. I can't tell you where it is. Other than that,
that very statement makes me think we would probably be best off letting the district court consider it before we decide it ourselves.
I mean, that would be one way that the court could proceed, but I would just note that in this case, it seems as though any declaratory judgment that would be issued would be really a distinction without a difference to some extent with an injunction. I mean, expecting that the government, would comply with declaratory relief if the court found something to be unlawful. And so we would ask that this court, if this court issues judgment on the merits, which we would also ask that the court do, there'd be no reason for that remand in the first place.
Can I ask you to help me think through an issue we haven't talked about yet, which is if the plaintiffs are right on the merits, and if they're also right about 1252 F1, you still have the argument that there's no irreparable harm here because I guess you're not irreparably harmed if you're detained by someone who's not allowed to detain you, so long as you could be detained by someone who is allowed to detain you. And I am pretty skeptical of that and give you an opportunity to address my skepticism. The hypothetical I'm thinking of that I have found helpful is imagine I have a mortgage with PNC, but Bank of America forecloses on my house. Seems like if they get an order to take my house, I've been pretty irreparably harmed, even if PNC would have been able to get an order to foreclose on my house.
I take your point, and I admittedly haven't looked into any of what the foreclosure laws are in this country, nor am I familiar with that area of law.
It's not a property law point I'm making. It's just a general principle that, if somebody is like harming me in a way that I'm not going to be able to get back my injury, that seems like irreparable harm, even if maybe someone else would have a right to inflict the same injury.
I think with respect to deprivation of liberty, it's not. And I mean, obviously, I can see that I've looked at the cases we cite to are Section 1983 cases, but there are a plethora of 1983 cases throughout the country which come to the holding that if there is a cause for detention by one law enforcement agency and someone, for example, is not transferred on
What
the
if
day.
NS had been kidnapped by a private citizen? Would that be irreparable injury?
Well, I think that that would certainly be a tougher case for me to argue, but I mean, it's not the case that's here. I mean, here we have two law enforcement agencies that were working together. I mean, you can look at the wants and holds cases throughout this country. And again, it's not an argument we preserve for appeal, but law enforcement agencies throughout the country, before they release someone, will look up wants and holds and say, is there another agency that this person's wanted for? And then they may hold that person for an hour, 2 hours until there is coordination. And so I don't think you would say that there's been a deprivation of liberty in those circumstances. And if you look at the 1983 law across the country, if you have somebody who is in custody in one state and there's extradition to another, and the extradition order is supposed to be executed by the 30th day, and for reasons that no one understands, the extradition order takes place on the 31st day. There have been 1983 actions for Fourth Amendment violations and for Fifth Amendment violations, and the courts have, and I've looked at the cases I've looked at, the courts have said, no, there's no deprivation of liberty in those circumstances, because whether you're being held by Connecticut or the neighboring state of New Jersey, you would have been held regardless. And I think that that is the closer analogy to this circumstance than the mortgage situation that you've noted. If there's no further questions, I had reserved 3.5 minutes for rebuttal. If the court will allow me to have any rebuttal, I'd appreciate that.
We will allow you to have rebuttal, and we'll hear now from Mr. Is it
Thank you.
Gonan? Gonan?
Good morning. May it please the court, Daniel Gonan on behalf of NS and the plaintiff class. I do want to address a couple issues about the whole warrantless, warranted arrest issue. But before that, I want to focus on the key reasons why the U.S. Marshal Service do not have lawful authority to detain or arrest people based on civil immigration violations. The first is the Accardi principle, which is the principle that the government is bound by regulations. In this case, we have regulations that say only a specific list of designated immigration officers who have undergone required training are allowed to serve I-200 warrants or make warrantless arrests. It's undisputed that the marshals are excluded from those lists. Second, the termination of the marshal's delegated power when all of immigration enforcement authority was transferred from the Attorney General and the Department of Justice to the Secretary of Homeland Security and the Department of Homeland Security under Laurel Bay. That transfer terminated by operation of law any prior delegations by the Attorney General, and certainly was superseded when the Secretary of Homeland Security issued a comprehensive set of regulations specifying exactly who could exercise these powers. And finally, the Chenery Doctrine, which is the principle that the 2002 order that the marshals are relying on really can't be read to confer the specific power to make arrests for suspected civil immigration violations. So as I understand it,
Because it doesn't recite the correct authorities, the 509, 510 argument?
that was good enough for the district court judge. We've kind of expanded on that on appeal. And it's really, the way I would say it is the fact that the 2002 order doesn't cite the INA's delegation authority is one piece of evidence that calls into doubt the whole notion that this was a delegation of authority to make routine civil immigration arrests. The order doesn't talk about serving a warrant. It doesn't talk about a warrantless arrest justified by likelihood of escape. It doesn't talk about probable cause. It says you may locate and apprehend someone who is in violation of the immigration laws. So if you contrast that language to the language that's in the regulations delegating arrest power to immigration officers, it seems like two different things.
Well, the 2002 order specifically talks about immigration arrest, doesn't it?
It talks about locating and apprehending people who are in violation of the immigration law. So not people for whom there's probable cause to believe that they are, or reason to believe, as I believe the regulation puts it. So it's different language, and it doesn't say anything about warrants. It doesn't say anything about, in the absence of a warrant, there's a statutory requirement that the arrest be justified by likelihood of escape. It seems to apply to fugitives, which is why it uses the terms locate and apprehend, which are typically done in these fugitive apprehension programs. And the marshals have separate statutory authority to participate in fugitive apprehension programs as directed by the Attorney General. Now, we know what the Attorney General had in mind when he issued this 2002 order. We know from the accompanying memo that it was the NCERS program.
Which wasn't about fugitives at all.
Well, it was not defined in terms of fugitives, but it was used as a fugitive apprehension program. I believe John Ashcroft gave congressional testimony where he talked about how they had captured hundreds of criminal and terrorist suspects pursuant to the NCERS program. So, I mean, the language of the order is admittedly not strictly limited to the NCERS program, but that's what the Attorney General had in mind. And we know, or at least we have strong reasons to believe, he didn't have in mind the practice that the marshals are doing in Superior Court, because the order doesn't talk about any of the things you would expect it to talk about if he was trying to add, if he was trying to amend the regulations that say only these people can make these arrests. It would say, notwithstanding the authority delegated in 8 CFR, 287 C5, or 287.5 C1, the following U.S. Marshals and Deputy U.S. Marshals are authorized to serve I-200 warrants. Now, he couldn't even delegate the warrantless arrest power because by statute, that can only be delegated by regulation.
Do you contest that there was an I-200 warrant for NS?
I do not contest that there was an I-200 warrant for NS. I contest that it has legal significance for several reasons. Number one, we don't know when it was issued. We know it was issued on January 14th, 2020. We don't know what time it was issued. We don't know if it was issued before or after the marshals, NS had been ordered released by the Superior Court and the marshals detained him. We know it was served by an ICE officer in Lorton, Virginia, later that day. So when it was issued, we simply don't know. I think we can infer from the record that the marshals, whether the warrant existed, the marshals were not aware of it because it's not in the certified administrative record prepared by the marshals. And their own policy says, I believe it's on JA45, that they will try and get the copy of the paperwork. So presumably if the warrant exists and they tried to get it, they would have had it in the administrative record.
Let me ask you a question about this related to this.
Sure.
Does the district court's injunction cover class members for whom there are I-200 warrants that Marshal Service was aware of, that were served properly, that the timing was all the T's dotted, all the T's crossed and all the I's dotted?
Yes, it does.
If we decide that 1252 F1 bars the class-wide injunction, would the district court be able to enter an injunction just to NS? And I think part of what I'm thinking about is mootness.
I don't want to concede that it would be moot because I can imagine circumstances where it wouldn't be moot. For example, imagine, I'm not saying this is true, but imagine there were a pending Superior Court warrant for NS such that it was foreseeable that he would be arraigned in Superior Court, next week or something, then it might not be moot as to NS.
Is NS in the country?
I actually don't know the answer to that. I can tell you he was released by ICE at some point, but I don't know the status of his immigration matter.
But the release was at a pretrial stage, was it not? So presumably he's due back.
I believe his Superior Court case is terminated.
Okay.
But certainly at the time.
And at the time it was filed, he was in custody at the Superior Court.
Yeah, and he did.
And so he had standing because it was an ongoing
Yes.
detention, and he had a likelihood of reappearing at the Superior Court because he was being prosecuted there.
That's right. He did have future court appearances. I mean, I assume the court could take judicial notice of the Superior Court docket that shows he did in fact make subsequent court appearances.
And just clear, I'm not so worried about whether there was a mootness issue when the order was issued. I'm imagining, and I know you don't want us to vacate the injunction, but if we did, what would happen then? And I guess, why was it terminated? To the extent of this is in the publicly available record, why was the Superior Court case terminated?
My understanding is that he took a plea.
Okay.
And served probation.
And then you said you don't know if he's in the US. Do you have to be in contact with your client in order to be representing him here today?
Well, I represent the class. So he's the name.
You don't have to be in contact with the class representative. I'm not, that's not a rhetorical question. I'm genuinely asking.
To be honest, I don't know the answer to that. I personally have not been in contact with him. There are other people at the Public Defender Service who work on this case who may have been in contact with him.
If I may, I want to ask about the forfeiture issue
Yeah.
on the 1252 F1 issue. Imagine that it is something that could be forfeited, and imagine that, and it quite clearly was not preserved in a way, in an ideal way.
Mhm.
But imagine I don't think it's waived. Imagine we're talking about forfeiture now. There are exceptions to when we would enforce forfeiture, and the briefing covers a couple of them. I wonder if another reason to excuse forfeiture is a public safety reason. And I'm thinking if lives will be in danger because people with criminal records who the executive branch wishes to detain and has the resources to detain are not being detained because of a class-wide injunction. If that kind of public safety factor should be a reason to excuse forfeiture.
Well, the government hasn't made that argument, but to sort of address it, every member of our class is, I guess by definition, someone for whom a Superior Court judge has said, you are not a danger to the community. You can be safely released in the community pending whatever you're charged with, or other members of the class or people who the U.S. Attorney's Office has looked at the arrest paperwork and said, we're not charging this person. This person shouldn't even be charged with a crime. So I don't think I don't think the record would support that kind of a public safety rationale. And I don't think I think
that's a strong response in that.
Okay.
But imagine that the executive thought this person was dangerous enough. I get that the Superior Court judge didn't. Imagine I think that there's some public safety. I think that there is some risk to public safety if this injunction goes forward. Is that a fair thing for the court to consider in whether to excuse forfeiture, or is that just off the table in terms of factors we should consider?
I think it would be too much to say it's off the table. I mean, I think probably the court can consider anything it wants to consider in deciding anything supported by the record, at least, in deciding to excuse a party's forfeiture. Of course, the injunction doesn't prevent anyone from being arrested or detained by ICE. It doesn't prevent that. And, ICE, it doesn't even prevent the marshals from doing it under a certain set of circumstances that could happen in the future. And I think the parties are basically in agreement that the difference between class-wide injunctive relief, which arguably is barred by 1252 F1, and class-wide declaratory relief, which until today, I think the government had conceded is not barred by 1252 F1, and this court has said is not barred by 1252 F1. We all agree there isn't really much of a difference at the end of the day. So the public safety rationale, doesn't come into play. The marshals, I think Ms. Feudham basically said, they're going to comply with a declaratory judgment. So the policy is going to be the same.
Even that is in a little bit of tension with what the Solicitor General said about declaratory relief in the supplemental brief that I mentioned earlier, and, I take Ms. Feudum to speak for the Department of Justice today, but I also take the Solicitor General to speak for the Department of Justice.
Sure, and I guess because this case only involves the marshal for the Superior Court of the District of Columbia, even if it were not a class-wide declaratory relief, and even if it were just a declaration that detention of a person under these circumstances violates the law, I mean, presumably the Marshal Service would comply with that.
But then that does run into the possible mootness.
It does run into the possible mootness issue, which I think what this is pointing to is all the reasons we've cited why the court, assuming it is forfeited rather than waived, shouldn't exercise its discretion to reach the issue. There are a number of legal issues that would arise only if the court chooses to excuse the forfeiture. The court would not need to reach those issues if the court holds the government to its forfeiture. We've cited, the prejudice to the class, and it's not really within the policy of 1252 F1. And, whether I understand, looking at legislative history to interpret what a statute means is controversial, but looking to what the statute's purpose is to decide if we should excuse a party's forfeiture and rely on that statute, I think does make sense. And the congressional history, the House report that's cited in the NIJC brief, amicus brief, makes it very clear that Congress didn't want to prevent litigation about the legality of arrest and detention. They left all these avenues open, including injunctions, just not class-wide injunctions. And the legislative history makes clear that they wanted these things to be litigated. They just didn't want, one district court issuing a nationwide injunction that's going to stop the whole, systemic system from operating while the litigation plays out at various levels.
I don't think they love the idea of statewide injunction either.
Well, this is one court. It doesn't even apply in all of the District of Columbia. It doesn't apply to the marshals in the federal district court. So it really, the only, Robert Dixon, the named defendant, is the only person, and his deputies are the only, entity affected by this. Unless the court has any further questions, I see my time has expired.
Yeah. I'm just making sure there aren't questions I wanted to ask you before you sit down. Thank you.
Hello again. I'd like to start by just speaking for a moment about the forfeiture issues with respect to 1252 F1 that were raised. 1252 F is a jurisdictional statute. It divests the court jurisdiction or authority. And I think in their papers, the appellees drew a distinction, or perhaps confused, I should say, subject matter jurisdiction, which we don't contest, with jurisdiction to issue a particular remedy. And it's clear from looking at the Texas v. Biden case that the statute does contain a jurisdictional divestment from the federal courts. And in fact, if you look at, also I believe there was a Fourth Circuit case that we cited in our papers, Miranda v. Garland, from 2022, finding that the government did not waive arguments under 1252 F1 by failing to raise it in the district court, because as a jurisdictional limitation, it's not subject to waiver. I would also note that at the time this case was litigated before the district court by the U.S. Attorney's Office, Elman Gonzalez had not been decided yet. So the scope of 1252 and its particularly expansive scope had not been carved out and set forth with such specificity by the Supreme Court. I'd also like to note that 1252 F1 doesn't say that if the class is a narrow one, or it only affects a county or a particular geographical range of society, then the prohibition is somehow waived. 1252 speaks to class-wide injunctions, and this case clearly falls under that. I also wanted to respond to something that Mr. Gonen said about we can fairly infer that the marshals were not aware of this I-200. I just don't think that that's fair to say. I concede it was not part of the record, but I don't think we have any indication as to why it was not part of the record what the marshals as an institution were aware of in 2020 or 2021 when this case was litigated, what some point of contact pulled out of a file versus what the marshal who executed this warrant at the time was aware of. I just don't think we can draw any conclusions from that. All we know is that it does exist right now. Mr. Gonen has conceded it existed, and at the district court, it was always litigated. The last point I just wanted to make briefly was regarding Chenery, because we really didn't get to speak to it at all when I was up here before. But the rubric of Chenery doesn't require that every single statute that provides authority for a particular action be cited. So when you have a statute like 28 USC 510 and 8 USC 1103A4, which provide coextensive authority for delegation, there's no authority or precedent that would require the Attorney General to have cited to both. I know the district court pointed to the Giordani case and said that there was a problem there with the fact that the Attorney General cited to Section 510 with respect to a wiretapping delegation. But there, the issue was that there was a competing statute which limited the delegatory authority for wiretapping. Here, Section 510 and 1103A4 are not in tension. And it would also just be our position that Chenery doesn't apply in the first instance, because this is not a question of discretion, of policymaking, of fact-finding, of an area where the agency has sole expertise. This is simply a question, a legal question. Did the Attorney General have authority to act? And for the reasons stated in the government's brief, the answer here is unequivocally yes. We would ask that this court overturn.
I suppose it could be a policy decision not to invoke a particular authority.
I suppose in certain circumstances, perhaps it could be. I know that there was the media case out of this circuit, which I believe you were on the panel for many, many years ago, where there was a discussion as to whether or not the Communications Act or the Reform Act was invoked because it had to do with jurisdiction of appellate issues. And perhaps in a case like that, there might be. But because depending on which authority was invoked, there was a different path to review. In this case, there'd be no imaginable policy reason to invoke 510 over Section 1103 because it doesn't lead to a different place. There's no distinction in terms of review. They both provide the same level of delegatory authority. And focusing back again on the media case from this circuit, an agency's power is neither widened.
Say that, but then 2002, that authority is picked up, correct?
Say that again, I'm sorry.
The authority, you say they're both delegatory authority is the same in two different sources, so it doesn't matter which one you see. But then in 2002, the second source is invoked, isn't that correct?
In 2002, they cite to 510, and in 1996, they cited to the Deputy Attorney General, she cited to 1103. And so my position is that it doesn't matter. I mean, my position would be it doesn't matter if either one is invoked because the Attorney General has inherent authority to make subdelegations, and that
So
the Attorney General
could have invoked nothing.
Could have invoked nothing. I mean, the delegation starts with, the 2002 delegation starts with by the inherent authority, by my inherent authority, including, and then he also lists by my authority as Attorney General. I'm not quoting, but it's something to the effect of referencing the inherent authority. So our position would be, could have cited nothing because Chenery doesn't apply. Whether or not the Attorney General has that authority is a legal question that either he has it or he doesn't. And even if he did have to cite something, he could have cited either one. It doesn't make a difference.
But the difference is that 509 and 510, which the 2002 order does expressly cite, are about general Attorney General authorities, and what is it, 1103
A4
is about, INS authorities, INA authorities.
Yeah, I mean, I take your point that it's more specific, but it's more specific in a nature that there's no tension between the two.
Well, there is in the sense that what kind of aid, is the Attorney General rendering the marshals immigration officers, or is it saying as marshals doing the things that marshals do, you should help out? And I mean, there's a lot of difficulty in attempting to grandfather something that was, purpose built for a very different problem.
Well, I mean, I think we don't really know, I don't know that we can say that the language in the 2002 delegation is narrow enough to that, is so narrow that it applies only to the NCRS. I don't think that's the case. It's broader language. I don't think that 1103A4 and 510 are in conflict. Is one more specific? Sure.
I take your Giordano argument. I do think that that doesn't quite cut it. It's not a limitation that the invocation of the broader authority is somehow overbearing.
Yeah, well, I have nothing further. The court should overturn and vacate.
Thank you very much.
Thank you very much.
Case is submitted.